Ms. Butler, you're talking over me again, and I really don't want to hold you in contempt today. Knowing the rules of evidence and knowing the rules of procedure and how everything works, you told me you would do that, that you couldn't come back later and say, well, Judge, I was a bad lawyer, or tell the higher court, well, Judge, I was a bad lawyer in my own trial. I did a terrible job and I've been convicted of this.
No, just argument at this point.
Okay, that's fine. Yeah, Ms. Butler, so is there any evidence you wanted to present to the court?
I have a lot. I'm so sorry, Judge.
Well, before you
But
get
I can tell
started,
you one thing.
before you get started,
Okay.
I need to have your attention for this. Do you plan to testify today?
To explain everything, yes,
You plan to testify?
I can.
Okay, so I'm going to put you under oath
Okay.
when you testify. Do you understand that?
Yes.
And you know what the Fifth Amendment is?
I can waive my rights if I, not to self-criminate myself.
So you understand what the Fifth Amendment is, that you don't have to give any statement that would be incriminating?
Yeah.
Did you know that if you testify and I put you under oath and you testify, that the prosecutor is going to have the opportunity to cross-examine you?
This is not trial, is it?
Ma'am, this is a hearing,
This is a hearing.
and there is evidence that is being presented at this hearing. And if you are under oath and you testify, the state's going to have the opportunity to cross-examine you.
Okay.
And if they ask you a question, you're going to have to answer it.
Okay.
You understand that?
Yes. Can I have?
And that you can't invoke your Fifth Amendment rights after you've already waived them.
Okay.
You
Can I
understand
have-
that?
Yes.
So I'm going to have you answer whatever question they ask.
Okay, that's
You
fine.
realize that?
Yes.
You're willing to accept that risk.
Yes.
Okay, you understand that it's probably not in your best interest.
It's probably not in my best interest at this time, or.
Do you understand that?
I do, not really completely, but before we move on to the prosecutor interviewing me, can we please interview Andrew first?
Ma'am, it is your case. If you want to put
Yes, can we bring Andrew up?
Andrew, I'm sorry,
you
it would
please
be
come
more
with
formal if I
Andrew?
knew your last name, on the witness stand, then you could have him testify. Would you like to call him as a witness?
Yeah, well, I can call him as a witness, please.
Okay, then you're going to want to say, I call.
I call Andrew as a witness to the stand, please.
Okay, sir, please come on up.
Klimek.
Thank you, sir. Ma'am?
Okay, Andrew, when you attend to the interview, was you sitting there witnessing both our actions, George actions and my action? Was you notating this? Yes
I
or
was
no?
present at the interview and I took notes, yes.
Okay. Towards the end of the interview regarding to the statement, do you witness George reading the statement?
I don't recall
Okay.
if he did or not, but I'm sure that Special Agent Vasilko read the statement with you.
So okay, let me ask you this question. How far apart that you were standing by each other that you could not see him reading?
We would have been close. Are you talking about during the interview?
Yes, because it was very small.
Yeah,
It was
we
very
would have been next to each other.
Exactly. So you trying to say you did not see him pick up a piece of paper that he did not read the statement? You didn't see him at all. So is that what you're saying?
Ma'am, I've interviewed with Special Agent Vasilko several times,
Mm-hmm.
and he is pretty thorough.
Mm-hmm.
And typically, he would review, again, when statements are completed, that
Okay.
they would be reviewed.
Okay, so I'm asking, did you see him read it? That's all I'm asking.
Again, I don't recall for sure, but I'm sure he did.
Okay. Now, next question. Did you ever see George give me the statement back and told me to write again? I had to write the first time. Then I wrote again, which was the second paragraph.
I'm not sure what you're asking.
I'm gonna ask you again. Do you ever see me sitting down, writing down the statement? True or false?
I believe you completed the statement that day, yes.
Okay. Did you see me hand the statement after I got done?
Yes, it was given back to Special Agent Vasilko.
Okay.
Next question, over.
Did you see George hand me back the statement?
I think you gave it to Special Agent Vasilko. He would have reviewed it with you. And then obviously it was taken so he could put it in his case file and it would have been presented to a prosecutor and then USPS management.
Did you did you see George stand there by the door, pacing, and stated that he would not accept my statement unless I write that I took food and gas? Did he ever make any type of statement like that?
I did not see that.
So you're trying to say that you didn't hear anything and you was sitting right next to him?
Ma'am, I believe that are you talking about the food and gas comment?
Yes, that food and gas comment. That's the only one I'm really trying to get you right there. Did you ever hear George make a statement that I need to admit that I took money for food and gas?
I did not.
Okay. No further question.
Okay. Cross?
Yes, Your Honor. Just one moment. Thank you, Judge, just briefly.
Thank you.
Agent, and I apologize, how do you say your last name?
Kleeback.
Kleemak, thank
Yep.
you. Agent Kleemak, you were in the interview room, correct, with Ms. Butler and Special Agent Vasilko?
Yes,
And did you witness the defendant writing her statement?
I did.
And at any point in time, did the defendant ask to rewrite the statement?
No,
And at any point in time, did Agent Vasilko or yourself suggest that Ms. Butler should write in?
Yeah, I just need to hand it back to her. Let me get everything marked. And Ms. Butler, I'm gonna have you bring that up to me. I'll make a photocopy of it so that we don't take your last copy.
Were you, but I just thought,
Is it a 4-page document then, ma'am?
no, it's just 3 pages.
Okay.
It should be 3 pages. Or,
Looks like there are 4 pages there.
but it was just basically this part here.
So all I need to copy 1 page? Okay,
This one.
okay. But not the reverse side of that one? Okay. All right. If you want to hang out for a minute, let me make a photocopy.
Also, I have, okay, I can give you this copy. Okay,
Once.
okay.
PC load letter. What does that mean? Why does it say paper jam when there is no paper jam?
All right, Ms. Butler, so come on back up here. We're gonna have to make sure you're comfortable moving in and about the courtroom. These are your originals. All right, this is the photocopy that I'm gonna have you take to the court reporter. She's gonna mark that as defendant's exhibit number 1. So you stand over to the court reporter, she'll put a sticker on that. You're going to want to hang out for a second. She's going to hand it back to you. You're going to take it back to council table. All right. Now, take it back to council table.
I actually missed what Bill said. I saw you guys all laughing, and he was making copies, so I made a Office Space reference. So it wasn't wrong in my head. It might have just been poorly timed.
All right. Have a seat. All right.
Exhibit number
Now,
one.
would you like for me to admit defendants number one?
Admit defendant number one.
Okay, so you would say, Your Honor, I would move to admit defendants exhibit one.
Your Honor, I would like to admit exhibit number one.
State.
I'm going to be objecting. First of all, to relevance, first of all, I don't know what Ms. Butler is trying to get out of this exhibit. It's not relevant to her own motion today, Your Honor, the proceedings today. It has nothing to do with suppressing her
Yes, it does.
confession. And I would object to it's not authenticated correctly. If she got this from Mr. Stanley, he's not here to testify to the authenticity of this document. I don't even know what this document is. I believe it's some stamped stock sheet, but again, she's not going to be able to properly admit it without it being authenticated by whoever gave it to her, whoever wrote it.
Okay,
Can I object?
so I need your response on relevance.
Okay. First off, my name is on here.
No. Relevance. How is it relevant?
Is it relevant to this case? Is
No.
because
How is it relevant to your motion to suppress?
how is it relevant to, this is the motion, this is the statement that was given to the OIG. Because I mentioned something about, he wanted a copy, and I said something about Don. This is what I given him, because I wanted him to invest further.
Okay, but how is it relevant to the question that we have here, which is that the handwritten statement you provided was given by inducement, coercion, or improper promise? What does this document have to do with that?
Well, this document is basically, I know about the suppression about the statement, but I also put in there what was handed to him about that, what was given to him, because I remember I had asked for a copy of my statement so I can clear up some errors,
Okay,
but he refused to give me a new form.
okay.
And then I ended up also stating that I went in.
So you think it's relevant to
Yes, it is.
impeachment of their testimony?
Yes, it is, because
It's fine. I
Okay.
understand your position. Now, the state brings up that it's not properly authenticated. I ask you a few questions, preliminary ones, about how you got the document.
I got it through the post office, county, what do you call it? The files that I copied for him. It's the
Okay.
same files that he got copies of,
Okay,
and he went in and got another copy of the same document,
okay.
and it was given to him.
And so here I agree with the state
Mhm.
that you haven't properly authenticated the document. But in addition, it is hearsay. And it is hearsay that doesn't fall within any of our hearsay objections.
Okay, you say it.
Exceptions, rather, exceptions.
Mhm.
Because of that, I have to not admit it. But regardless, because you've offered it, we still need to take the document from you. So please rise up and bring it back up to me. I need you to bring it back up here. That's fine, but we need to take them one at a time. So I'm going to take this. Defendants one is not admitted. I sustain the objection to admissibility. What else, ma'am?
I have a daily closeout certification checklist.
Okay,
This is needed that he or management that's supposed to do on a daily checkout regarding to money orders, stamps, refunds. This is necessary because this is what he had asked me in the interview.
okay, hold on for a sec though. Let's try to get the document admitted. So you remember the process here? You're going to want to stand up, take it over to the court reporter. She's going to put defendants 2 on it. We're gonna be able to use that number for identification purposes. And then tell me more about it. How did you come into possession of this document?
I already had this document already,
Okay, how did you get it?
working there.
Did you run this report?
Yes, I had to run multiple reports.
Is this a report that you specifically ran?
No, it's just my daily checkout reports. Like, just say, for example, when I go downtown and go to the main, I would exchange reports because they'll run out and I'll just give them a copy of it because we have to wrap them up sometimes.
Okay, so let me ask you again,
Okay,
how did you come into possession of this report?
by working at the post office.
And while you're working at the post office, are you in files? Are you at a computer attached to a
Yes.
printer?
Yes.
How did
Files.
how was the document generated?
It's just copy. It was already generated. It's just a repeated copy.
Okay, now let me ask again then,
Mhm.
how was it generated?
Copied.
It was not copied. It had to have been printed first.
Yes, it had to been. Well, I was just telling you how I received it.
And on what system was it generated?
What system it was generated? I think management will use what you call it, Word, and they will actually generate all the information that we need to do on a daily basis.
Did you input all the data in to create that form?
No, I did not.
Did you sit at the computer and press print for that form?
No, it was already pre-printed.
Did you take the document that you found already printed and photocopied on a photocopy machine?
Yes, yes,
All right. And you're moving for the admissibility of defendant's exhibit number 2.
yes.
State.
I'm going to object to same issues. Relevance, Your Honor. It's not going to be properly authenticated in hearsay.
Ma'am,
No.
what do you have on relevance? How's this important to your question about whether your statement was coerced?
Well, according to my statement being coerced, he asked me about the ledger that's listed. And he asked me,
Okay.
it's in there, he
So
asked
again,
me.
you're using it for impeachment purposes.
Yes,
Okay.
he asked me.
Do you want to
which-
try to add anything about authenticity?
Hmm?
Do you want to try to add anything about authenticity of the document?
I mean, that's as best as you can get it. I mean,
Did you at any point look at the computer screen of whatever generated this document and compare the two to make sure whatever was on the printer screen, the
Mhm.
computer screen,
Mhm.
was the same thing that was generated by the printer?
we didn't never use the computer, Your Honor. Only
You
thing,
never saw the computer original of this?
no,
before it was
we
printed.
never used one from computer. It will always been passed through each other.
Okay.
Like we'll bring it downtown or the main, we'll make a few copies or send it in
Okay,
a
do you have any response on hearsay? Do you believe it
So-
falls in under any of our hearsay exceptions?
No, it's not hearsay. It's required because it shows, this is financial documents that I am presenting to you, Your Honor. Because you cannot present something, go ahead.
Ma'am, the question is to admissibility, okay? It might not be hearsay because I'm not really sure what it is altogether, but I think it is hearsay because it's somebody else's statement. I'm not sure what it's meant to do here because I'm not sure it's relevant. But in any case, Exhibit 2 is not admitted. It's not relevant. It's not authenticated.
very
I believe it
relevant.
to be hearsay.
It is
So
relevant.
please bring that up as well.
This sounds like an unfair trial, Your Honor.
It's not unfair, ma'am. There are rules of evidence. When you did your Ferretta hearing, you and I went through and talked about how you're going to have to be responsible for presenting evidence and you're going to have to be responsible for knowing the rules of evidence and knowing the rules of procedure and how everything works. You told me you would do that, okay? And I told you that if you do a bad job or if you're not able to get your documents authenticated, we talked about it specifically, or admitted into evidence that that was going to be on you and that you couldn't come back later and say, well, Judge, I was a bad lawyer, or tell the higher court, well, Judge, I was a bad lawyer in my own trial. I did a terrible job and I've been convicted of this. You can't come back and do that. So you have
Okay.
to be able to present your case like a lawyer because you've asked to represent yourself. And
I did, and I did.
I understand.
Yes, I did. And I,
Present the rest of your evidence.
I
We have
agree.
55 minutes left and we still have to get to your motions in limine.
so every time I present something, you saying it's not authenticated. I thought we was just talking about the motions like you said.
Everything that you try to admit into evidence here has to pass stringent rules of evidence before it can be admitted into this proceeding. It's not relaxed rules of evidence. This ain't small claims court, right? There are no relaxed rules of evidence. There are big kid court rules of evidence here.
So can I go get it authenticated and resubmit it?
No, ma'am. Today is your hearing. You've known about this hearing for, I don't know, a week
Just
or
last
so.
week? And the only thing you had mentioned
But
to
you
me.
would have had to have gotten the documents authenticated in advance, and I can't teach you how to practice law. You chose to represent yourself, and now here you are at your hearing, probably incapable of getting in the documents that you want to get in, even if they are relevant.
Mhm.
And it's not my problem. It's a
They just refer to her as Miss Butler. I don't know what her first name is.
you problem,
Yes, I understand
okay?
that.
And no, you can't go get them and come back because this is the hearing. You go to trial in like 2 weeks or so.
Mhm. So authenticate them. Oh my God. I think I might.
Here, if anyone wants to look this up, this is the information that ChatGPT gave me. So if you guys want to look it up and tell me what the case is actually about, that'd be amazing.
have some that I actually file.
I can't teach you how to practice.
No.
But do you have any idea what you would have to do to authenticate any,
Hold on,
either one of these?
I think I did it already. It was way back last year. I did authenticate them.
I don't think you have, ma'am.
I had actually got it.
I don't think you can authenticate them yourself, if that helps.
The documents came from the post office. No, I cannot authenticate them, but they are very relevant to this case and to this matter to order to prove theft.
Okay, ma'am.
They are very relevant.
But what about your motion to suppress, where you say that
My-
was coerced from you?
My motion to suppress is very truthful and
That
honest.
sounds like you're arguing.
No,
You're under
no,
oath.
no,
You're supposed
no.
to be testifying now.
Yeah,
Are you going to testify now?
I'm not testifying, but I'm explaining, then I will testify.
Well, if you're going to explain, that's argument.
Oh,
Wait
okay,
till after your testimony to give me whatever argument you're going to give.
okay.
Do you have any other evidence you want to present?
If it's not authenticated by me,
I mean, you could authenticate documents you produced yourself.
only thing I really did is my motions that I did.
Which wouldn't be evidence, ma'am. It's already part of our record.
Uh-huh. I got a question for you, Your Honor.
Probably not going to answer it. It's not question and answer time for the court.
Okay,
Time for you to be testifying or presenting evidence related to your motion to suppress. We are down to 52 minutes.
I'm gonna hurry it up. Can I testify then?
Go ahead. What do you want to tell me?
I want to tell you about my job.
Please keep it relevant to your motion to suppress.
Okay. I've been working for the post office for 17 years. And I always try to follow the rules and procedures. I was not really trained thoroughly on my position. Management have an internal responsibility for stamp stock, refunds, money orders, and everything that contain financially. When I discovered that management was not doing their job, I reported it to the EO. And they refused to train me when I got into that position. Also, I want to let you know that according to refunds, I actually requested through management to use the refunds because they would never offset the debt, or they would never look into it when I keep reporting it that keep messing my stock up because we have
Ma'am, I need to redirect you here,
I
okay?
need to say this though. I
I
gotta
don't
get
think
it
you
out.
need to say it because it's not relevant to what you've said.
It's in my
Want me to
statement.
Consider in your.
It's
motion
in
to
my
suppress.
statement, Your Honor.
Please don't talk over me because my court reporter can't type what both of us are at the same time. Your motion to suppress says that at your interview,
Mm-hmm.
that they coerced a statement.
They did. Mm-hmm.
Okay, and the evidence that you've just talked about in your testimony
Mhm.
has nothing at all to do with that.
Well, let's
So-
talk about my evidence then.
Talk about the
The-
interview.
The interview.
Talk about what they did to coerce you at that interview.
Okay, so at the,
Contradict-
okay.
Stop talking when I'm talking
okay,
and contradict whatever evidence you wanted to contradict while they were testifying.
okay. Let me close my eyes. At the interview, I asked my postmaster who was these two young gentlemen to come in. She said she didn't know. As I sat down, Andrew was on the right of me, sitting on a garbage can, and George was on the right by the door. He was standing there. He mentioned that about you do not have to answer questions. He did mention, he just stated that you can plead the fifth. At that point, I'm like, pleading the fifth for what? And as we proceeded, he started asking me questions to how long I've been working for my job and stuff like that. And I told him how long. And then I ended up start talking about the EFT. The EFT regarding to the money orders that we got scammed. I was talking to him more about that regarding to management did not intervene, and they end up making me pay for something that was irrelevant towards me because I wasn't not responsible because management did not step in to verify or also to make sure I was doing things correctly. And the only reason why I did the money orders is because Postmaster knew the customer. The customer wanted to set up a trust. And she came in and got money orders through me. So he didn't want to talk about that. He wanted to talk about the refunds. So I was like, okay, let's talk about the refunds. He asked me, did I know anything about the PVI, the meter, I think it was about the express. And I said, yes. And then he also told me to explain. And then he also asked me about the P.O. Box customer, about P.O. Box 509, which was Charles Morris. And he asked me about a money order. When he asked me about a money order, and it was $160, and I said, yes, I know about that money order. I said a customer had given it to me towards the end of the transaction because the customer, John Mars, was an elder. And I've been knowing him for over 10 years. And he was in a retirement home at the time. So he would have a neighbor, different random people would come up there and assist him and bring stuff and make sure his mail or whatever. When it was time for them to close out the transaction, the young lady brought me.
Someone else just sent it to me. Was it you, Captain Science? I saw a quick Discord message and had everything for her, but we got it. She's charged with theft from between 750 to 25,000 as a public servant. It's a level 6 felony. That's where we're at. And her jury trial is next month.
Do you have any grounds to object?
But my grounds to object that this is not a clear context statement. It doesn't state. It's not a clear statement, Your
All
Honor.
right, it's overruled. States 2 is admitted.
Judge.
I'm happy to have a look at it. In fact, I think I have to for this hearing.
May I approach, Your Honor?
Yeah, please. Thank you. Further questions?
Yes, I guess, regarding the statement, Ms. Butler. So again, this is your statement that you wrote, correct? And you initialed, at least like you initialed on each page of that statement, correct? Your
Yes, I initial with the little errors that I was trying to correct at the time.
And you also signed that statement, correct?
Yes, and I reserve my rights. Can you look at that?
Yeah, that's on the page. number.
Yes, it said without prejudice, didn't it? Doesn't it say without prejudice?
It does.
So that statement was written that way because I wanted to challenge it under circumstances I was under. Because there was nobody else but those two men and myself. And look, if you just read it,
Yeah, I have no further questions.
Okay, yeah, ma'am, did you want to add anything then? In sort of a redirect of yourself, did you want to try to say anything else?
I mean, like I said, I reserved my rights and I basically did that so I can later challenge it and let them know what the misconduct that occurred that led me to write the last paragraph. And also, it doesn't state that I took money from the post office. It doesn't say anything about the refunds. It doesn't state any type of criminal contempt for sin. No, because it's not a clear statement. I'm trying to figure out how can you submit it just because it got exhibit on it that it doesn't correspond with the probable cause. It doesn't. I mean, you got to put evidence that lines up so it can sound truthful. It doesn't make any sense.
This may be great for the trial, but we're here on a motion to suppress today.
I know, and it
I'm
needs to
only
be
trying to look-
suppressed.
I'm
because-
only trying to look at whether there is evidence related to the motion to suppress, okay?
Yeah, and that's it.
Anything else you want to add? Any other testimony you want to provide? Any other evidence you want to provide? Documentary evidence at this time?
Well, I would like to submit evidence that there's no proof of theft.
All right, that's not evidence, ma'am. That's argument.
It is.
Not, ma'am, it's argument. Most assuredly, it would be argument.
I'm-
That's not even relevant. So on the motion to suppress, state argument.
Thank you, Judge. Just briefly. So Your Honor, we heard from Agent Klemick and excuse me. Thank you, Vasoko today, Your Honor. They both testified that Ms. Butler, they interviewed Ms. Butler at the downtown Valparaiso post office, that when they first started the interview, she was given her waiver of rights form, which she stated she understood. She even testified today that she was told that she could leave at any time. She signed that form. She initialed. She said that she understood it. She still went forward with the interview. She was able to leave at any time. There was no doors closed. There was no hindrance for her to move about, to actually leave that interview, Your Honor. She wrote her statement, which is State's Exhibit 2. She wrote that out free and voluntarily. We heard testimony from Agent Vasoko that at no point did Ms. Butler ask to rewrite that statement. Ms. Butler signed that statement, dated it. We heard testimony that she was not coerced in any way. She wasn't made any promises regarding her putting certain things in that statement. Your Honor, given that, and this was a non-custodial interview, she was told that at the very beginning. Given that, Your Honor, her statement and the interview should not be suppressed.
I object, and let me tell you why I object to.
Wait a minute, ma'am. Wait a minute, ma'am.
Okay.
State, thank you.
Yes.
I just need now for you to argue. Sure, it's an objection, but it's just your contrary argument. Go ahead.
The
Argue
reason why I
in support of your motion to suppress.
the reason why I object, you can't just up and leave out of an interview. We are taught to cooperate. And whenever an officer is presented, you must cooperate. And we're not taught to leave from any type of interview. We have to comply. If I wanted to leave, I would have left, but I couldn't leave. I was in a situation on the clock and I was instructed by a postmaster. It's not like I did it at home. I was instructed by the postmaster to speak with them. And by me be given instruction, I cannot just say, no, I'm not talking to them. So when I went back there and spoke with them, I cooperated with them and not knowing who they were, because by not being a small office, different random people come there all the time to talk to me about retail products and all kind of improvement. So I'm thinking they're one of them. I didn't know who they were. And still they start asking questions and we've been scammed. So I'm thinking they coming to talking about the scam that we've been scammed on. So of course I'm going to comply and talk about the scam, what had happened at the post office. I have record of that too.
Anything else you want to add, ma'am, on the motion to suppress?
I just want to know through my suppression,
You want to,
That-
what?
in my suppression, that the OIG now follow procedures, protocol procedures. I just want to know that they follow procedures.
Okay. All right.
That's all I want to know.
All right, Ms. Butler. Did you get the copies of the state's witness and exhibit list for trial?
And I,
I've been in the envelope that my staff just gave you.
Oh, one more thing.
Oh,
One more thing, Your Honor.
go ahead.
With my
All right, before we get to the one more thing, I just love how she's raising her hand. Like, there's only two of you, or sorry, there's only three of you in this conversation right now. You don't need to raise your hand. Legal Fiction, thank you so much. I give this super chat while reserving my rights without prejudice. Does that mean I'm allowed to use it, or does that mean I have to keep it there because you're reserving your rights? I don't know. I don't know. Thank you, Legal Fiction. I appreciate it. And good to see you tonight, bud. Phil, thank you so much for the 5 gifted memberships. Welcome to the 5 new members. Thank you, Phil.
suppression, I did mention something about documents, financial documents. Because I'm trying to figure out where is the documents.
Ma'am, do you believe you have all your discovery in this case?
I think I did put that in there.
You received everything from the state?
I didn't receive, I only receive certain things, but there's no financial documents in there.
Did you get your records from Mr. Pribble?
Yes, but no, he sent them to me email, but
Okay.
he did not hand give them to me.
Do you object to us having your email address so that the court clerk can email you orders and things from the court and make it part of the Odyssey system for serving you documents since you're pro se? Can we have your email address?
Yeah, you guys have my email address.
We don't have it. Can we have it?
Oh yeah, I can give it to you.
What is it?
T.
Yeah, I'm not giving that email address out. I have a feeling there would be people that would actually try to email her off of this video.
24@gmail.com.
You want to approach?
Yes.
We'll start with the witness list. You're going to have a seat with that stuff. They filed this yesterday. The state of Indiana filed this yesterday. So you can see they've got their witness list there. And just because they've listed these witnesses doesn't mean that they will all be here or that they will all testify. You understand that? This is a list of witnesses, but it doesn't promise that they're going to offer testimony or that they'll even be here. I want you to realize that. Do you understand? Yes. Okay, and do you see the exhibits there? Spend some time with the exhibits. Looks like there are about 9 things. Well, there are 7 things and then some catch-all.
Well, for everyone that's joking around, there's a very good chance that this video will be on at least 2 other channels by the morning. So they're not the best at muting. You can probably get it over there.
Okay, so this is mine, okay? Can I ask you a question about one of these exhibits?
I'm waiting.
Just one, not exhibit, witness. Where Dory,
Yeah, I was joking. No one do that. No one absolutely do that. I'm pretty sure you guys know that I was being sarcastic there, but that is the quickest way for courts to stop showing it on, stop streaming their stuff. So, yeah, don't do that.
the
Go again?
postmaster, would she be able to attend?
I don't know.
Because that's the one that I need to really address some things with her because.
Last time we were here, I told you that if you wanted me to have people come, I needed you to get their addresses and things.
But the state has Dory on there. Dory is one of their witnesses. And
Irrespective of that, I just explained, just because she's on this list doesn't.
doesn't make sure, this is very unfair, Your Honor.
What's
because
unfair about it, ma'am?
Where's unfair is that the young gentleman just was deceitful on the stand regarding
Ma'am,
to
I
my.
have accountability. I'm the one who decides whether or not somebody lied here today. You understand that? That's what I do.
I got you, but
That's what the jury's gonna do during your.
Yeah, and it's just, this is my first time, so please have mercy on me. I'm learning, I'm observing, I am trying to get through this. I'm the one is a victim in this matter. I'm been going through all this. While they still have their jobs, I'm jobless.
Ms. Butler, all I'm trying to find out is.
My statement needs to be suppressed because it does not clearly state who, where, when, and how, and also.
Ms. Butler, we've moved on from your statement and the motion to suppress. We're now talking about witnesses. You've suggested you want Dory Veligan here. I just told you if you want her here, you need to get her address to me. So I can get a subpoena.
I don't know, because I left that post op 3 years ago. I don't know where everybody stays.
I don't either. And I'm not gonna do your super sleuth.
But that was part of, I thought the state would know where they live because they part of their witnesses.
Not their job. So
Well,
if you want to guarantee her appearance here as best you can, you need to get me her address, and I'm going to put a deadline for addresses. We're set on the 18th, right?
Yes, Your Honor.
So I think a week from today, July the 30th, if you're going to get if you want any subpoenas sent, you have until July 30th to get that to me so I can get subpoenas down to the clerk and they can get them served. Even
So-
with that, it's going to be tight.
so you trying to say that I don't have no evidence in the record? And that's what you're saying, that I can't submit no evidence because my stuff been submitted already in the record?
I never said anything like that. I don't know what you mean by it, but what I did say earlier today is that you're going to have to learn how to authenticate evidence and make it ready for submission in the trial. Nobody has any evidence into the trial yet, if that was what you were suggesting.
Okay,
The trial hasn't started yet, so there's
Okay.
no evidence into the trial yet.
Okay, so can I ask you this question? Because I'm learning from you. The evidence that I have, can I still present them at trial?
I will allow you to attempt to present relevant evidence, but
Okay.
you're going to have to follow the rules of
I will
evidence for
follow.
admissibility.
Okay, thank you,
And
Judge.
you're going to have to authenticate documents, and they're going to have to be ones that are admissible. So if it's hearsay, meaning it's a third-party statement, then you got to figure out how to get that in.
Okay, if it's a hearsay, I would try to,
teach you how to do that.
No, I will find, I will figure it out. Thank you.
Figure it out. All right. So you believe you have the exhibits that are recited in the state's list of exhibits? There's no question in your mind that those 7 items are in your possession at this time? The acknowledgement of rights form, the spreadsheets, the written statement, your interview, photographs, videos, police reports?
Okay, hold on. It's the defendant knowledge of right form. Spreadsheet, summarized losses, fraudulent activity from 2022, defendant sworn statement, defendant interview, photos, video, police report, any exhibit listed by the defendant. This is what I had requested in a sense, but then it looked like,
Did you get the video evidence from
I never,
Mr. Fribble?
nothing. Nobody gave me nothing.
You don't have the video evidence from Mr.
Nothing.
Fribble?
They didn't give it to me.
I have that, Your Honor. It is quite lengthy. There's several videos, so I can, today, I can have it put on a USB and have, Ms. Butler pick it up from our office.
Yeah, Ms. Butler, you can either pick it up or they can send it to you, but I'm going to put a deadline on the state to get
Can I-
video evidence prepared before the end of
Can
the
I
day.
say something about the video? Can I say something about the video?
We just need to stop talking over each other, but yes.
Okay, the reason why I don't really care about the video, Your Honor, is because management gave me authority to do what I
Ms.
did.
Butler, regardless of whether you care about the video or not, insofar as the state has a duty to provide a complete set of evidence to you,
Mhm.
they are going to fulfill that duty.
Okay,
Right? And if they don't, they are going to face disciplinary consequences. Do you understand that? So they're going to get you that. You need to pick it up in their office before the close of business tomorrow. If you don't come pick it up by the close of business tomorrow, that will alleviate them from any further responsibility. You understand that?
Can I ask you something? Yes. About the state, I just have a concern. This has been in my mind. The state, why is the state taking this case as though they have full disclosure of this case?
Good heavens, Ms. Butler.
No.
That is certainly not the subject of anything to do with today's hearing.
No, I was just asking because why is the state questioning me like they was there? Because I'm trying to figure out, I'm going against the state versus myself,
Ms.
right?
Butler,
No, I'm asking, why is I'm going against the state versus myself? Why is this not the United States Post Office versus me? Why is it the state versus me?
Ms. Butler, I certainly don't have time to explain.
I need
Oh,
to answer the
that-
question.
No, you don't, because I'm not
Because
here.
in the
I'm not
Constitution,
here to answer you.
Constitution, Section 6, it said I have the right to face my accuser. And in the state, it's not my accuser. She's not, or he's not. I need to face my accuser, and the accuser is him.
Ms. Butler, let's get into the motions in limine. I've got
You
one
gotta
motion in
explain
limine.
that to me, Judge.
I'm not going to, ma'am.
You have to, because it don't make any
You do not have
sense.
to. I
So
think
basically, anybody can just go against the state, and the state is considered as a
you're representing
business.
yourself in this
Yes,
matter.
I am, but I need to maybe cross-examine my accuser, and the state is not my accuser. I'm trying to figure out why is the state versus me?
Ma'am,
Because I do have a right to cross-examine them.
ma'am,
My accuser got to be a living, breathing individual, not a representative
I
of
need
the
to
state.
redirect you again.
No.
okay?
Yes, it did, Vic. I'm so sorry. I actually meant to thank you earlier, but I'm glad to see you in the chat tonight, and thank you. I appreciate it. Yeah, you're awesome, man.
I
You
just
wanna
want to know
input
why.
that search into Google?
No, I'm wanting to know
Hearing
why.
Or some other search engine of your choice?
Constitutional right, Your Honor.
Ms. Butler, you're talking over me again, and I really don't want to hold you in contempt today.
I'm so sorry, honey. I wasn't trying to. I just want a question answered. That's all.
It's
I just
not
want
our
a
position
question
to
answered.
answer your questions in that regard, Ms. Butler. That's a legal question that you're going to want to consult with either an attorney or some other way to find out the answer to that question. But we're not here to give you the legal justification for how a state files cases on behalf of victims in the criminal court. Anyway, please turn to the motion limiting number 1 regarding juror nullification. Ms. Butler, do you have any objection to the proposed motion limiting number 1? Do you have the document in front of you, ma'am? We've only got 20 minutes left and we need to cover 6 pages. They have 10 they've asked for.
I was muted. They had a Feretta
Do you understand
hearing
what
already.
journal?
So during the Feretta hearing, it's when she went full soft sit, which is why I just call her a wannabe soft sit now, because she hasn't done it since. She's still, like the whole, she has the right to face her accuser. That she got close, but that's all she's done since her first hearing. But yeah, she had a Feretta hearing.
Occasion is
So this is the list of motion to inline. And it's inline, what is this talking about? My statement to keep it within?
no, ma'am.
What is this?
Number 1 is juror nullification. Juror nullification roughly is that even if the state proves its case, that you can't stand up and tell the jury, even though they've really done a good job proving their case, you should not convict me of this for a variety of different reasons. And you can try to invoke, I don't know, bias or sympathy or a hardship discussion, whatever. Or, you can't say to them, hey, put yourself in my shoes under the same circumstances, you wouldn't convict me. That's what juror nullification is in a nutshell, roughly. Do you object? telling you, it's a standard motion. But I just need to have words from you, whether you object or not, so I can make a ruling. I've only got 19 minutes. You do object?
Yeah.
Okay, we'll grant the motion in limine number 1 over the defendant's objection. Did you want to try to articulate an objection for the record? No? Okay, 2 is evidence or argument related to maximum, minimum, or potential penalties that you may receive. And I should just say that one of the instructions that you'll see from the court to the jury.
No, she was talking to the bailiff. When the judge was threatening her with contempt, the bailiff started walking towards her, and she just put her hand up to towards him, like, stop, I'm sorry, honey, I'm not. Yeah. So that was who she was talking to.
Is that they don't have any part in sentencing. Only the court has a part in sentencing. And I think that's what this motion is tied to. It's a run-of-the-mill motion in limine that I normally would grant. Do you have an objection?
I don't have an objection. You're responsible.
2 is granted without objection. 3 is exclusion of discovery requests or comments regarding discovery in the jury's presence. So all this means is if something comes up during the trial about discovery, that you don't want to talk about that in the presence of the jury. You need to bring it either to the bench or you need to bring it, and I'll go through this procedures a little bit. We're going to be digging into the lunch hour here in a second, but you need to bring that to the bench or we'll dismiss the jury and talk about it outside the presence of the jury. Or in some circumstances, we would talk about that in chambers, but I think normally we do it out here on the record. Do you have any objection to number 3? Ma'am, you have to answer so that the.
No, Your Honor.
Pick you up. Number 4 is prior bad acts. This would be prior bad acts of witnesses. Is that right, State?
Yes, Your Honor.
Okay. So here there's the possibility, I suppose, of you being able to bring up prior bad acts under certain circumstances, although I think it's very limited in a case like this. 4 deals with just talking about any sort of bad acts any witness might have done that you know about.
Oh, okay.
Related to their testimony, unrelated to their testimony, I should say. Do you have any objection to 4?
No, this.
Okay. And then 5 is possible effects on you. And you talked about that a little bit today, that you don't have a job, that a felony conviction would ruin you, that it, take away your gun ownership rights or whatever. You can't talk about that in front of the jury. Do you object to 5?
Yeah. I don't object. I get it.
Okay, 5's granted. And then 6 is on affirmative defenses. That any defense that you might have had, I don't even know what it would be here, that you didn't raise can't be brought up in front of the jury.
I object to that.
You object to 6? Okay, 6 is granted. Did you want to try to articulate response for the record? Okay, 6 is granted over the defendant's objection. 7 is about your character. So you can't talk about how great a person you are in front of the jury. It's not an element of this crime, the alleged crime. Do you understand that?
Yeah.
Okay. Do you have any objection to 7?
No.
7 is admitted without objection. What about 8? Similarly, about truthfulness, untruthfulness of witnesses, where you can't stand up and say, hey, I know for sure that the postmaster is a liar. You can't say that. You understand that?
Yeah, you are.
Okay, any objection then to number 8?
I want to object to that because I want to be able to say that.
You do want to object?
It says this aiding request to court.
Did you want to try to articulate the objection for the record?
I want to be able to say they are not saying that they're not being truthful. I want to say something like that.
Okay, you're not going to be able to. You'll be able to impeach their testimony.
Why not? I cannot be able to impeach their testimony?
You will be able to impeach.
Okay, I will be able to impeach their testimony.
Under these rules.
Okay.
But you can't stand up and say, that's a lie.
Oh, I can wait So basically I'll just have to wait, or I can just say object, Your Honor.
You can object, but you can't say object, she's lying,
Okay,
or he's lying.
okay,
I'll talk about it in a minute, but like during the presentation of evidence this morning,
okay.
you got emotional about answers that you heard that didn't agree with your recitation of the facts. And under your breath, you were muttering that that's a lie. You can't do that in front of the jury or there's going to be a mistrial or worse. You understand that?
Mm-hmm.
Okay. Nine is self-serving statements. So self-serving statements are ones where you try to get your own hearsay evidence in, is basically the thing I see most often, where you've prepared documents of your own that you try to get admitted, or you have documents of your own that you try to get admitted that are self-serving to your own side, which wouldn't be admissible because they're.
I haven't seen much of Judge Simpson all week. He had a short docket yesterday, but that was it. Yeah, I don't know. A slow week for him, or maybe he's in conferences. I really don't know.
They're hearsay. You're here to testify, so you just testified about it.
Okay, I was just here, I don't necessarily need to bring any evidence. Evidence can speak for itself, or I can
You
just
may need to
testify.
bring all kinds of evidence, I feel. But you
Yeah.
want to enter?
Wait, I just thought about it. Judge Simpson might be busy doing stuff for Lauren Brown's memorial and things that have to do with that. That's probably where he's been this week. I should have thought about that before I responded.
Pose an objection to 9 as well.
Let's see. Self-serving statement, counsel or witness refrain from mentioning. I don't have objection to this.
Okay. 9 is granted without objection. And 10 is your pro se status, which I'll talk about a little bit. There's not a specific instruction for the jury, but I do mention it a little bit. You're not allowed to bring that up and say, hey, I'm just, a little pro se litigant here. Be easy on me, be gentle with me, that kind of thing.
No, that's not that.
Okay. Any objection then to 10?
No.
All right. Motion limited number 10 is granted without objection as well.
Ugh.
So I mentioned a little bit about the proceedings here, how you're not going to be able to give emotional reactions from the bench. Or from the counsel table. Let me just tell you, when we have the jury trial, you've never sat at this table over here before,
No.
but you're going to be sitting over at that table.
Okay.
Okay. And the reason that we do that is because the jury box is right here. We want to have the defendant further away from the jury box.
Okay.
Is the reason why we do it. I don't know why we conduct business the other way without a jury. Nobody's ever told me that.
Whisper to the jury, maybe.
But it's been that way for the last 50 years, probably.
Maybe because I need to be away from the jury.
In any event, the other thing that is important is that you don't do narrative objections, which means that when you object, you would rise and you would have either say nothing, or you would rise and state an objection, judge objection. That stops everything. And then everybody comes up to the bench. All right. I have a microphone here, right?
Mhm.
That is a sidebar microphone, it's called.
The sidebar.
And then we will have a sidebar conversation
Okay.
about whatever objection you might have. We'll pause for a moment because my court reporter is also going to put on some headphones and put some white noise into the courtroom so that everybody else out there can't hear what we're talking about. Okay? That's how we handle objections. That's how we handle sidebar conversations. And that's how we'll handle strikes during the voir dire, during the jury selection. Okay? Let me talk about jury selection a little bit. When you come in, you were nervous at the beginning of this hearing, and I just want you to be conscious of the fact, and I talked about it a little bit during your Feretta hearing, if I remember correctly, there's going to be at least 6 people in the jury box here, and a 7th one typically we only have 1-day trials this one day.
We had set for 2 days, Your Honor.
We have it set for 2, so we might do an alternate juror. 7 people sitting there the whole time, right? You're going to be having a little bit of distance from them because you'll be on that side of the room, but you understand that there's going to be a bunch of people in here that are strangers to you. Are you gonna be able to still be okay? I mean, I try to,
Deal with post office workers. We are weird. So yes, I can do
but
it.
I'm just saying you were by yourself here in an empty courtroom earlier today and you were very nervous and you had difficulty.
I'm learning, Your Honor. This is new to me. This
I
is very
understand,
new.
but this is gonna be even newer when there's a room full of people.
Yes.
And when you come in for the jury selection, the entire room is going to be filled.
Okay.
And you're gonna have to start, the state's gonna go first, but you're gonna have to stand up after the state's done with their part. And the first words out of your mouth need to be a proper voir dire question. You understand that?
Proper dear question.
Voir dire,
Oh dear, proper
VOIR,
VO.
DIRE. And you're gonna have to know how to do that.
And I get it, Your Honor. Is there another way besides this?
I'm not sure what you mean.
I want you
A trial by combat. Let's go. I'm down for that. Let's go.
to draw up a, because okay, let me say it like this. I don't want to go to trial. I don't, honestly. And the reason why I don't want to go to trial is because I have so much evidence that there's no proof of loss.
Ms. Butler,
I understand. I'm just talking. Just let me get it out.
I just need to stop you, okay? Because I'm not allowed to be part of any negotiating.
I know I'm not going against you, but then
You're not going against me, but it sounds to me like you were roping me into negotiating.
No, I'm not going. No, I'm not.
Ma'am, when you talk about what evidence the state does or doesn't have, that's not something that I'm concerned with. That's something that you need to talk with them about
I,
in the process of trying to negotiate something with the state,
I was,
not with me in the room. And I'm not going to permit it. So I don't need for you to talk about what evidence they have or they don't have in front of me.
okay, so I can't talk to them.
I don't know if they'll talk with you or not, but it's
Okay.
also not incumbent upon me to
Okay.
force them to talk to you.
Okay.
They can do what they want.
Learning.
They can refuse to talk to
Learning.
you, or they can offer you some sort of a plea. I'm not going to be involved,
Mhm.
okay? That's the only other way I know to resolve a case like this,
Okay.
right? Is that you can go to trial, or you can do a guilty plea, or work out some other resolution. The other possibility is you could waive jury, right? But that's
Mhm.
something you're going to want to have some time to think about. It's not something I would accept
But
today.
that
without-
would be the bench trial without.
And then you'd be
jury.
trying it
Mm.
just to me, right? And then I still can't be involved in negotiations,
Yeah.
but then I'd be the sole decider of
Yeah.
the case and the evidence.
Can I also say this? Okay, I know that if you can produce the charges, the amounts, the fees and everything, can you do that as well? Like in the order?
I
Cause,
know what you mean.
I'm trying to figure it out. I know the charges is against my allegiance. I know it says, I'm on the behalf of that. So what I'm
The
trying,
charges are what?
allegiance, you know what that allegiance is?
No.
You never heard of allegiance? Allegiance? It's a creature at law. That's what that is. That's what that is.
Ms. Butler, that has nothing to do with this
Yes.
whatsoever, and I'm going to stop you, okay?
It is because it
What I
means,
will do, I'm stopping you. Please don't talk about whatever this is. It has nothing to do with this case or this proceeding.
it's,
What I will do is tell you that if you're going to waive jury, I need to have that discussion.
Does anyone know what that is? I have no idea. Someone, I hope somebody knows what that is. I don't know.
Decision. I mean, we're right on the cusp of summoning jurors. Do I have another trial set that day?
this is unfair, Your Honor. That's the reason why I don't want to go, because this is an unfair trial.
I still think we'll be okay. I'll give you until, again, a week from today. If you're going to waive jury, you need to make that determination before July 30th.
It's just unfair.
I'm not sure what is unfair to you. What
Because-
is unfair?
Let me tell you why it's unfair.
Yes.
Because I've been drugged.
Oh, ma'am.
You guys got evidence of me being drugged.
Ma'am,
And then y'all using that towards me.
Ma'am, no one drugged you.
Yes, yes.
No
I
one's
was-
using any
I
sort of-
went to jail. I've
You
been in
didn't
a
go to jail,
mental
ma'am.
institution, and they told me I couldn't leave the mental institution unless I take medication.
Ma'am, there was a
My
procedure.
violation, I've been so violated. Judge, I'm tired. I wanted to dismiss this. All I've been doing is suffering, suffering, suffering. And then I know I have a right to a speedy trial. I had a public defender. He didn't help me. And now I presented all kind of evidence. He didn't even try to assist me, authenticate or anything like you were telling me in advance. A whole year of my life just been wasted. Wasted. All kind of violations, like you saying that the United States Post Office or the OIG are victims. Where the court created a victim by drugging me and then use a judge that is actually about to retire to even carry out an order and put it under fraudulent, saying that I'm in a higher level 1 through 5, like I'm a danger to myself and danger to others, and drug me just in order to submit me. The Judge Jeffrey Clymer stated to the prosecutor that this is not a mental case. Do not send her to no mental institution. But you guys did. I am messed up. I'm messed up in the head regarding to how can I, this is an unfair trial. And then I'm up here talking about my statement and they not, oh, we don't know what you're talking about. Oh, we don't know what you're talking about. Yeah, submit it in. It don't even talk about the refunds. It don't talk about theft. It don't talk about nothing. It's just have a lot of statements, unorganized throws. And now I want to go ahead and submit. I'll just submit it. That's unfair, Your Honor. I've been through a lot.
Ms. Butler, are you asking me to once again consider whether you're competent to?
This case, Your Honor,
Will deny the
due
motion
to,
dismiss.
they do not have evidence of loss. I have proof of that. They did not do their job. It's a one-sided contract, one-sided interview. Because according, I've been working for the post
Ms.
office for
Butler.
17 years, Your Honor.
Butler, things are going off the rails pretty significantly here. I need to stop you.
A verified complaint, because if you read the probable cause,
Ms. Butler,
there's so much going on in there.
Ms. Butler, you need to stop talking, okay?
It's unfair.
A few minutes ago, you made a suggestion that maybe you're not competent to withstand trial.
It's unfair. I can see the unfairness.
Are you suggesting I should revisit the question of your competence?
Now, witnessing this, that is unfair. When a judge recused himself, it automatically will be an unfair trial because you didn't ever had it from the beginning.
I need a response to
From the
my
beginning.
question.
You
Are
didn't,
you asking me to reconsider your competency?
it's not reconsider my competency. It's just that I am stressed. And I've been going on for 3 whole years.
So you said you're messed up in the head.
No,
Do you think that you need me to reconsider
I'm
competency?
messed up in the head. I'm messed up how the system is so messed up until you try to voice your opinion, trying to conduct good business with the courts. And you try to be reigned in honor. That's what I've been doing from the very beginning. Remain in honor. And I'm like, okay, I don't know how to file the documents because this is my first so-called alleged criminal case. And I'm up here trying to cooperate with the judge. But I get drugged. I already went to jail. Already. And then I get a forced plea. Take the plea. I said, I would take the plea if you can show me financial evidence of loss. If you were to look at the document, sir, it doesn't have a financial evidence of loss. But I mean, you gotta have proof. They said, have you ever heard the saying, it doesn't matter how much you know, it's what you can prove in court. And I've been trying to prove what I have here in court.
No, no one's ever heard that statement. She just made that up. That's good. That's really good. I need to write that down. Judge Fish, write that down. I know you haven't heard it either.
That there's no evidence of loss. That is it. No evidence of theft. No evidence of misconduct. I'm trying to explain this to you.
Ms. Butler, I need to cut you off, okay?
I'm done.
We're done with the hearing. I think I've got everything I need for the pretrial. I'm not really sure that I covered everything I wanted to cover for the pretrial. Did you have any questions about how we'll conduct the trial?
I don't believe so, Your
A
Honor.
jury trial? Did you have any other questions about how we conduct a jury trial?
We gotta have a jury trial, because only somebody else outside this building can understand, because they know how the system is.
Well, if you reconsider that, like I say, you've got until July the 30th, which is a week from today, to waive jury if that's what you choose to do. I wouldn't coerce you any other to make a decision one way or the other. And then the other deadline I gave for next Thursday was for addresses for subpoenas, if you want me to get witnesses in. And then with that, we're adjourned.
Thank you.
All right. I've got the suppression.
This courtroom session delivers a powerful warning about second chances, responsibility, and how quickly one bad decision can change the course of a young person's life. The judge begins by addressing a defendant who is being placed on probation, but instead of simply reading the conditions and sending him away, the judge makes the consequences crystal clear. The court emphasizes that probation only works if the defendant takes complete responsibility for everything he has done and follows every condition imposed by the court. The judge warns that if he minimizes what happened or fails to take probation seriously, he could be right back in that courtroom facing a 2-year prison sentence. It is not presented as an empty threat. The judge explains that probation is an opportunity, but that opportunity comes with strict expectations. The judge then goes through the conditions in detail. The defendant has an ignition interlock device installed in his vehicle, and the court warns that any positive alcohol result could become a probation violation. The message gets even stronger when the judge explains that the defendant cannot consume even a single drink of alcohol while on probation. If probation determines that treatment is necessary, the defendant will be referred for treatment and will be expected to follow the court's orders. But the judge also explains the other side of the situation. If the defendant follows every rule, completes everything required, and stays out of trouble, probation can become a genuine opportunity to avoid serving the 2-year sentence in prison. The judge makes it clear that the choice is ultimately in the defendant's hands. Follow the rules, and the opportunity remains. Violate them, and the consequences can come crashing back. The courtroom then moves to another defendant, and the judge's tone becomes especially serious when the subject of weapons comes up. Treasurer Harris had previously pleaded guilty to